Right, good afternoon, class.
Good afternoon, sir.
Sir, good afternoon, sir.
Good afternoon, sir.
Good afternoon, sir.
Good afternoon, sir.
Sir, I think you're muted.
Yes, I just noticed that. Thank you very much. So, yesterday we couldn't meet, and I'm glad that today we are here together, and we shall make progress in line with our course outline. You recall for the past few lectures, we have been looking at topic 1, which covers the major introductory part to this particular course. And so today we are taking it a little further, and we'll be looking at the historical development of Nigerian legal system. And that will cover, it will be mainly the history of our legal system. That is how we got to where we are, the various stages that we have seen as a people, what characterized those different stages of our development, and so on and so forth. That's what this particular topic is going to help us to achieve. And of course, one of the ways we can understand what we are dealing with is to understand our history, because history is very important to enable us appreciate the present, and then we'll be able to know move forward properly. So we are going to start the lecture right away, and the topic again is historical development of Nigerian legal system. Now, by way of introduction, the topic is going to cover some timeline structure in our legal system. And this timeline covers the major political development of our dear country, Nigeria. And that we start from the pre-colonial Nigeria to take us to the colonial Nigeria, and then the post-colonial era that we are in right now. So this class, we look at 3 major timelines, like I've said. I would like to repeat that again for the purpose of emphasis. The number 1 timeline is the pre-colonial judicial administration. That's number 1. Number 2 is the colonial judicial administration. And the 3rd one will be post-colonial judicial administration. So we're going to start basically with the first one, which is the pre-colonial judicial administration. Mind you, the topic that we are looking at is the historical development of the Nigerian legal system. Now, I'd just like to ask, have we looked at the nature of Nigerian legal system in this class? Duality, external
Yes,
influence.
sir. Yes, sir, we have.
Yes, sir.
Okay, good. All right. So as we discuss this topic, you will begin to recall why we discuss all of those features, or why those features can be deemed to be the special features of our legal system. And I'm sure that for those who attended those classes where we dealt with all of those, we appreciate the current topic more. So let's start with the pre-colonial judicial administration. Now, the judicial system in Nigeria has evolved and metamorphosed over the decades. And also, depending on the type of government, the government structure that were in place as at that time. Apart from the structure of government in place, the system of government in place as at that time were the things, or were what determined how the history of our judicial system progressed. And we need to mention here that prior to colonization exercise in many parts of Africa, the traditional society had their own system of adjudication. And this system of adjudication were responsible for the administration of justice in those societies. So what we are saying, therefore, is that prior to when we were colonized, let's say the entire Africa, we as a people had our own system of laws that were indigenous to us. No matter how crude they were, no matter how unreasonable, or no matter how unfashionable they may be, yet they govern the lives of the people in practically every area. We talk about marriage, talk about land ownership system, we talk about agriculture, we talk about economics, we talk about finance, we talked about the court system, we talked about the system of policing, and every other thing that operates within the society. Talk about the police system. The people were able to organize themselves into a well-structured body, and then all their needs as it relates to law, or that relates to legal aspects of their life, were met by their own structure. But nevertheless, the entry of the European commercial actors into the African society led to the development of judicial system that laid the foundation for the future of contemporary adjudication in African society. Mind you, we need to mention here, and as a way of being realistic, we need to mention that our own indigenous system were unique in their own sense. And it would be wrong also for anyone to think that the judicial system that we ran as a people were inferior to other people as at that time. But even though when put side by side, the judicial system that we ran as at that time may not be as sophisticated as what was obtainable in other places. And be that as is as may, it does not in any way invalidate the system that we had as a people. And that's why we continue to maintain that we had our own system and they worked for us, they met our needs, they served us, and then made the society to live in an organized setting, not crude, but was able to meet our basic needs. Therefore, they were not inferior. Our systems were not inferior in any way. But when the colonial masters or the people we call the European commercial actors stepped into the territory of the African nation, they began to introduce some sophisticated or a more advanced system that probably were operational in their various locations. And then that began like as the foundation for the future of contemporary adjudication in the African society. Yes, we agree that came with some form of varieties or some aspects that could help us develop our own system of law. I give you an example. For instance, in the 19th century, before the annexation of Lagos in 1861, the different society that now form Nigeria and other African countries operated their own political system with their own method of administration of justice. Maybe somehow, the system they adopted then were even more effective than what we have at this time that we refer to as contemporary times. In those days, from what we read in the books, if a theft is alleged to have taken place and there is intention of the community leaders to find out who is responsible for the theft, it's always noticed that these communities have different ways of doing this. They will say, okay, we may have to go to the shrine, and we are not accusing anybody. We do not have any intention to say Mr. A committed a crime or Mr. B. All we want to know in a fair manner is who committed the offense and what punishment should be given accordingly. They push all the suspected individual back to the shrine, and you will realize that before the person who actually committed the crime will get to the shrine, you'll have looked for a way to confess that, oh, I did it, because they know the consequences of when the gods are angry. And then people were scared to commit crimes because they are aware that their sins will find them out one way or the other. Unlike this contemporary time that we live in, a man may commit an offense and will run to another country for shield. And then he may remain there for life without any form of justice. And now that's how we're advocating for universal jurisdiction for some crimes. That irrespective of the location of the crime, the individual should be able to face punishment. And in facing punishment, he should be able to pay dearly for what he has done, and also in a way to prevent reoccurrence in the society. So the African society in the during the pre-colonial period had their own system of administration of justice. They have their own way of punishing those who have held against the state. They have the way of making those who have committed wrong to put their victim into what we call pre-victimization stage. And that's why today we have things like compensation, we have things like restorative justice. All of that were parts of our indigenous African society before the arrival of our colonial masters. During the pre-colonial era, there were courts, traditional courts for that matter, where traditional rulers or traditional rules and regulations were applied against parties, irrespective of whether they were indigenous of that community or even foreigners. Once you are part of the community, you are made to be subject. You are made subject to the courts of the land. And then the law, the rules, the customs, the regulations are applied to such individual. As a matter of fact, it applies generally to everyone within the society. Let's look at the Igbo land, for example. There was an acephalous society, which is a society without central leadership. So in that system, leadership was distributed among members of the community who sat in council to exercise executive, the legislative, and judicial powers. We have elders in councils, we have the Igwes in council, we have structures put in place, and that's why up to date, our African society, or let's say Nigerian society, the indigenous part, where core customary rules and regulations are still applied, these systems still operate there. And they were able to lead their people appropriately in the way they should go. They made laws for themselves, they executed the laws, and when there is need for judicial interpretation, officers of state, who may be in the chiefs, the rulers, the baales, the Igwes, the emirs, He performed these functions absolutely well to the benefit and growth of the society. And then let's look at the Hausa pre-colonial system. That system was the closest to the modern court system that we have today in different parts of the world. You look at your history book, talk about maybe when you did government, or of course you did some political science topics before moving to your 200 level. You must have been refreshed as to what constitutes the Hausa system, the pre-colonial system in the northern Nigeria. In that place, there was a court system in which subordinate chiefs or alkalis headed, even in different zones. And that's why today we have magisterial districts, we have customary courts in different locations, in districts, and so on and so forth. Why the junior chiefs, who we refer to as the subordinate chiefs, and alkalis manage minor matters where there is need for appeal. The emir serves as the appellate jurisdiction to ensure that serious matters are attended to. So of course, you look at the contemporary time we have. We have a hierarchy of courts where the likes of the magistrate court, customary court form the lower court. The high court forms, of course, like a middle between the lower and the higher court, where decisions that are reached, which parties are not satisfied with, can be appealed to. And then from there to Court of Appeal, up to the highest courts in the land. These systems were prevalent during the colonial era. And then the people, like I always say, were able to manage their affairs, and then they enjoyed themselves. Then one other major thing we need to mention about this pre-colonial time is that the administration of justice was based largely on unwritten customary rules. Because, of course, the process of codification then were not popular. So, they operated majorly on unwritten customary rules. And these rules were interpreted by various institutions and individuals that exercise judicial powers within the community. They perform their duties where they need to interpret, they interpret rules. And thank God the elders are there. The elders, they are laden with sufficient wisdom by virtue of their old age, by virtue of their experience. They are able to interpret customs, rules, and regulation of the people. Class, I believe you can hear me. Can I have some form of confirmation, please?
Yes, sir, we can.
Yes, sir.
All right.
Yes,
We can hear you, sir.
Okay,
Sir, please, can you repeat what you said about the emir under the Hausa pre-colonial system?
okay. I said that the alkalis or the subordinate chiefs play the role of the lower courts and they manage less serious matters, which may include maybe some minor infractions, minor thefts, and all of that. But the emir serve as the appellate court by handling serious matters, issues that may pertain to maybe murder, heresy, and maybe rape or other heinous crises, crime. So the system that they ran as at that time were able to meet the what we can say are the modern day system. They interpreted the laws, they made the laws, they even exercise the executive powers at the same time. What about social punishments? They have their own system of social punishment, which include ostracism and banishment, as the case may be. All of these systems, these forms of punishment were very common. They even engage in corporal punishment. And then this pre-colonial era of our time witnessed native rules and even some more like imported kind of traditions also. Even though some of the people may apply what they started seeing around them, may not even understand what it meant, but one way or the other, they try to incorporate it. And mind you, as at that time, the Europeans were already in Africa. They were relating with us. And then the indigenous people also had cause to learn from their ways of life. And by so doing, they were also able to learn some of their ways of life. But what can be said, therefore, is that with the increasing growth in European trade in the African region, British traders became involved in the politics of the region as well. Even in the administration of criminal justice. Or, don't let us even be specific. Let's just say administration of justice, which could, one way or the other, have some link with civil and criminal, as the case may be. The European increased in the region. The British traders became involved in the politics of the region, and also they interfered in the judicial administration. And then the traditional system of judicial administration at that time posed a problem for the foreigners. Ordinarily so, it should be so, because the customs of the people are unknown to them. But fortunately and unfortunately, they are now in Africa, trading, engaging in commercial activities. As a matter of fact, I do not think that they were not involved in marrying our people. So they engaged in commercial activities, they engaged in marriages, they engaged in contracts. If not so, how could they have presented ordinary mirror to our forefathers and they got acres of land? Ordinary mirror. Of course, is contracts. Irrespective of what you are parting with, what is important is that you get something in return. A man may choose to give out his birthright for a bottle of wine. Pure contracts. So because the foreigners began to integrate, began to interact with the indigenous people, they began to have problems with the indigenous system that was operating at that time. Particularly the European foreigners who were unfamiliar with the traditional laws in many of the African society had a series of problems. The customary court system could not take care of their needs. And consequently, it led to the introduction of the consul courts. The consul is C-O-N-S-U-L courts by the British government. And then the British government appointed consuls to handle dispute between indigenes and foreign traders, while the traditional court continued to administer cases involving only indigenes. This is the foundation of the division of our legal system. The introduction of foreign practice separated from our indigenous customary practices. So this led to the creation of the consul court, while the consul court handled issues that may arise between foreigners or foreigners and indigenes. The traditional courts administer the indigenous people. An example is the Oil River Protectorate, which later became the Niger Coast Protectorate. It's a formation of the British authority. This Niger Coast Protectorate, for which councils were appointed by the British government to observe treaties and handle the government of British in the area that they have already taken over. And that was what eventually led to the Protectorate of Southern Nigeria. The colonization process was gradual. But from being gradual, it was systematic. And then, as at that time, when the Protectorate of Southern Nigeria was already in existence, the Court of Equity had been introduced in the mid-19th century. So consequently, the Protectorate of Southern Nigeria had embraced equity as a system of laws. And of course, that will prove to us that they also would have tested the manifestations of the common law system because of their interaction. And that's why we said that our legal system, practically everything about it, had some form of foreign interference. The involvement of the foreigners affected or influenced our own system at the end of the day. And then the system that have been established by the British government were able to administer commercial relationship between those who are now considered as British subjects and non-British subjects. You will recall that gradually and systematically, the British government had established its presence through the Niger Coast Protectorate, and then which led powerfully to the creation of the Protectorate of Southern Nigeria, and the courts of equity came into being, into operation, and then they were able to handle cases between indigenes and foreigners, or between those that can be classified as British subjects, having colonized their lands, and every of their being, they were made subject to the creation of the system that were in place as at that time. Mind you, this system were also in a way different from the council court, in that they were less technical and related to the administration of commercial relations and than government and justice issues. Of course, the people were more interested in their own success. And that's why the company that was introduced was made to rule. You wonder where a company to provide leadership. Of course, that was the avenue that began the colonial process. So consequently, the court focused on administration of commercial relations other than government and the justice issues. And like I said, and I repeat again, the introduction of these two systems, that is the local, the indigenous system, and the foreign system, was the beginning of the bifurcation of the legal system of many of the British territories. Meaning that when the British take over a particular territory, they retain their indigenous system and infuse their own British system gradually. And mind you, there were already communities forming what is presently seen as Nigeria today. And those foundational work that were done by the authorities of the British is still part of our system to date. Consequently, we'll be able to see that up to today, all this infusion into our system still remains intact. And that gives us the summary of the pre-colonial justice administration as a part of the three timelines that we are going to look at. So we move on to the next one, which is the colonial justice administration. Now, I don't know if you have any question regarding the first one that we have done before we move into the next topic.
Good afternoon, sir.
Yes,
Yeah.
sir. Yes, sir.
Can you explain that?
in the 19th century, before the annexation of Lagos in 1861. You said something happened. I didn't get that statement, so I would like you to go over it again.
Please, you have to speak up so that I
Yes,
can
sir.
hear your voice.
You said in the 19th century, before the annexation of Lagos in 1861. I didn't get that statement. What happened?
That I said in 19th century.
In the 19th century, yes, before the annexation of Lagos, which happened in 1861. You made a statement. I didn't get it.
How will I remember all that I said in the course of a long lecture? I'm
So
trying to.
you said
What did you say?
before the 19th century, that is 1861, different societies control their own political system with their own method of administration of justice.
I can barely hear you.
So I said in the mid
Can you use
19th
your
century.
normal voice?
Sir, can you hear me now?
I think it's better.
You said in the 19th century, before the annexation of Lagos in 1861, different societies control their own political system with their own method of administration of justice. For example, swearing through shrine and all that.
Okay. So what's the question about that?
I'm answering the question that she asked, that you said you can't remember.
Oh, good. Thank you very much. All right, I think we've been able to answer the question. Let's move on to the second timeline, which is the colonial justice.
I have a question.
All right. Yeah, go ahead.
Okay. Sir, when you were talking about the introduction of local indigenous, like you were saying something about the bifurcation of the British and the indigenous court that they operated together. I didn't get the word bifurcation.
It's BIFURCATION. Are you good now?
No, sir.
Yes. All right, so let's move on to colonial justice administration. Now, this period that we want to look at can be further classified into two, which includes the pre-amalgamation and post-amalgamation periods. That is, the colonial justice administration period can be further divided or classified into two. The first is the pre-amalgamation, and the second is post-amalgamation. Now, the pre-amalgamation period covers the period between 1861 and 1914. That time, the different parts of what is now known as Nigeria were administered by the British government or their subjects. So 1861 and 1914 happens to be that period of pre-amalgamation. While the post-amalgamation period refers to the period after the amalgamation of the colony and the protectorate of southern Nigeria with the protectorate of northern Nigeria to form what is now known and recognized as the Nigeria, or the better put, the Federal Republic of Nigeria. So those two periods are key and central to this discussion that we are having. Now, our focus is legal development. So let's move on that. So I like to say that after the session of, or what we call as in when you see it, you cut off. After the cession of Lagos to the British Crown in 1861, that is, when Lagos was assumed to be part of the British Empire, even though it was in Africa, the entire Lagos was seen as a part of the British territory. After that period, the Supreme Court Ordinance of 1863 established the Supreme Court in the territory of Lagos. So, the Supreme Court Ordinance of 1863 established the Supreme Court in the territory of Lagos. Of course, it was subsequently replaced by the Courts of Civil and Criminal Jurisdiction. All of these are process of development. And mind you, the Supreme Court at the time of its creation was the highest court in the land. But when the Court of Civil and Criminal Jurisdiction replaced it, that court also became the highest court in the land. For any appeal or decision reached by this court were laid to the West African Court of Appeal, which is popularly known as WACA, was situated in Sierra Leone. And where parties are not satisfied by the decision of WACA, further appeal is to the Judicial Committee of the Privy Council, meaning that there were already good structures that were coming up gradually. First was the creation of the Supreme Court, which was replaced by the Civil Court and the Criminal Justice Court. And then where there is need to appeal any judgment from that court, that appeal lies to WACA, that is the West African Court of Appeal. And then appeal from WACA goes to the Judicial Committee of the Privy Council. Also in history, going by the history, in 1874, the Gold Coast Colony was established. The Gold Coast Colony was established. And this Gold Coast Colony comprised of Lagos and the Gold Coast. You must have heard of the Gold Coast before, which is the present-day Ghana. So when the Gold Coast Colony was established, another Supreme Court Ordinance of 1876 provided for a Supreme Court for the colony, just trying to make it independent in some forms. And that Supreme Court, that the Supreme Court Ordinance of 1876 established, was to apply common law doctrines of equity and statutes of general application in force as at July 24, 1874. So, that Supreme Court ordinance established the Supreme Court again for the colony of the Gold Coast and Lagos, and it had the duty to apply common law, the doctrine of equity, and the statute of general application that were in force as at July 24, 1874. And then this was also it also led to some form of three-tier court system as part of the development that was taking place.
Sorry, sir, please, we are not hearing you because of your diagram.
Hello?
So you can go on now.
All right.
Go on. It doesn't ask me.
Yeah. So that court system created a three-tier court system, which was also in a form of, having layers or hierarchy. That is, just like what we had earlier when we were talking about the civil court, where appeal goes to WACA, from WACA to the judicial committee of the Privy Council. The development that took place after 1876 led to three tiers of court system. Number one is the district court, commissioners court. Number two is the divisional court. And the last one is the full court. And that means that appeal ran in this order.
Now, what did you call
One
the
of
last
the
court?
major things, the full court, F-U-L-L court,
Sir, please, and the second.
is
And
divisional
the first
court.
one.
The first one is district commissioners court, followed by the divisional court and the full court. So further development in 1886 rather, Lagos ceased to be part of the Gold Coast colony. And the colony and the protectorate of Lagos, comprising Lagos and the surrounding protectorate, had a Supreme Court, a new Supreme Court, which was different from that applied to Lagos and the Gold Coast as at that time. All of these are the series of development, court development, that took place as at that time. So there was Lagos colony comprising of Lagos and the surrounding protectorate. And a new Supreme Court was established under a new Supreme Court ordinance. And though it had similar provisions with that of the 1876 ordinance. Of course, the ordinance we're talking about there are laws establishing those institutions like the court and so on. But one thing we must mention at this time is that during this period, The indigenous court system also continued to flourish, although it was limited to cases involving indigenes, some of whom had imbibed the English way of life and now made themselves subject to the English law. I think it's not today that we started valuing other people's land or other people's way of life than our own. Or unfortunately so. So people who were governed by the indigenous customary law have started showing allegiance or movements to the English law. But where we are going is that I want you to note that what began as a wholly commercial relationship between the British traders and indigenous Africans later became a complex political relationship in which the British Crown dominated the political scene in Africa. So, all that they came to do at the beginning appeared to be mere commerce. But it went beyond that because they started administering the people, and so on and so forth. Please, can you give me just a second, please? All right, sorry for that break in transmission. So, what was more like commercial relationship eventually got into what became the political scene in Africa. And this can be seen in the experience of the Royal Niger Company, which began as the National African Company, a company doing business in the territories along the River Niger. And the company was empowered to administer justice in the territories where it operated. And then it established courts for this purpose. And of course, all of it, these are history now, but that tells us how the British penetrated into our system. The company that came to do business became the ruler of the people. And then, after the 1914 amalgamation, the bifurcation that we talked about before continued. Meaning that the system continued to further, further is getting broken into more and more classic issues. And then by that 1914 amalgamation, some of the proclamation that took place, another one established a Supreme Court for those territories. It also established what we call provincial court system. And at the end of the day, it also led to the establishment of a native court system. So what you will notice is that systematically, the foreigners succeeded in establishing themselves and create a system to manage their own needs and also the needs of the local people. And what they did was that the native court were empowered to exercise jurisdiction in civil and criminal areas that pertains to natives. And certain classes of natives were subject to the jurisdiction of the court only if they are residents in those locations. And then they succeeded in creating that avenue that you are indigenous, you'll be made subject to the native courts. And then the court can administer civil cases and also criminal cases. And all of these were the various developments that took place along this time. And again, further development in 1933. In 1933, there was further judicial reform that moved from the creation of the Supreme Court, the provincial court system, the native court system, and led to the establishment of High Court and Magistrate Courts under the Protectorate Court Ordinance of 1933. So the point we are making is that as the time progresses, in 1933, the High Court and the Magistrate Court system were introduced. Of course, that's why the High Court is still in our system today. The Magistrate Court system is also still in vogue today. All of these courts came into existence through the Protectorate Courts Ordinance of 1933. It was this ordinance that repealed the Provincial Court Ordinance. But the Supreme Court continued to exist. So the implication is that the magistrate courts came into play, the High Court followed, while the Supreme Court that was in existence earlier continued to serve the purpose of being the #1 court in the territories. So what happened consequently was that cases that were decided in magistrate court that parties were not satisfied moved to High Court, and those that were happening in the native courts moved to magistrate court, because we said that while all of these developments were still ongoing, the indigenous native practices were still ongoing. So meaning that whatever decision that is not okay by a party at the native court goes to the magistrate court, from the magistrate court moves to the High Court, from the High Court to the Supreme Court. And then, at that time, again, appeals was still moving from the Supreme Court to the West African Court of Appeal. And all of these were the more complex situations that we had in our system. So it was more of creation of court, removing of those courts that have been created, replacing them with other set of courts until when we were able to cross into the post-colonial period. And now to shed more light on what we have been talking about, all at this time, jurisdiction still remain bifurcated between the native and the English system, such that in some certain matters, for example, land matters under customary law, the English court did not have jurisdiction. Taiwo, I can see you. Please don't let me finish this line of thought so that I don't have to come back again and again. So the bifurcation was still there. That is, the English court could not venture into those matters that were the exclusive jurisdiction of the native court, and vice versa for the English court. But by 1943, a universal court system was adopted countrywide, and this led to the establishment of magistrate courts in all parts of the country, this country known as Nigeria, and a Supreme Court of Nigeria for the whole of the country. And that's why there's nowhere you go to practically in Nigeria where the magistrate court system is not subsisting. And again, the Supreme Court of Nigeria has remained in place up to today. So also are the other native courts that dealt with issues relating to our customary law and so on and so forth. And then when we adopted the federal system of government in 1954, the court system also adopted a federal stance. And what followed, therefore, was that high courts were established for Lagos and each of the 3 regions. So meaning that apart from the fact that those native courts existed, followed by magistrate courts that cut across the federation, high courts were established for Lagos and the other regions that the federal system of government had created as at that time. But there was a federal Supreme Court and magistrate court for the different parts of the country, like I said earlier. And these courts applied and administered English law, while the native court in the north and the customary court in the southern part of the country administer the customary law and custom, as the case may be. And then for the northern region, where Islamic Sharia law was recognized, was the recognized customary law, the Sharia Court of Appeal was also developed. So this period was able to lay a foundation that the native courts exist, followed by the magistrate court, followed by the high court for the region, and then for the north, where Islamic Sharia court has also manifested, there was room, there was need to create Sharia Court of Appeal to manage cases that may emanate from those courts. And then from all of these, the existing courts were able to manage and resolve conflicts that existed at that time. And then that can summarily be the end of the colonial era, which was practically dominated by the colonial masters who are taking over the system of government as at that time. So I'm going to take your question now, Eniola. Then thereafter, I'll take that only one question. Then we'll take an exercise. Thereafter, I can entertain other questions. Yes, Eniola.
Sir, please, I don't have a question actually. I just want to ask you to please help us to open the chat that is disabled because my laptop is currently on 2% and it's going to die anytime soon. And
All right, I'll stop places.
Thank you, sir.
It is now open. Now, so we're going to take a test now. I'm sure you are ready for that. It's going to be a 10-question test, which you will answer right about now. You should see it on your screen now. Can you see that? Hello, class?
No, sir. No, sir, I can't see.
You cannot see it?
No,
Why
sir, we
can't you
can't.
see it?
I've seen it though.
I'm not seeing anything, no.
All right, just hold on. All right. Let's leave that for now. Okay? Let's leave that. Let's just conclude our class for the day. Okay? So please put in your attendance. Then let me take questions before we call it a day. Any question? Or our history or story?
Sir,
Story?
I want to request for something, sir.
Yes, please.
Sir, please, can you give us the slide you are using, please?
Can I do what?
Like slide or materials you can refer us to.
You've been told what your textbooks are. So if you refuse to buy them, you are not going to be looking for shortcuts. And this video, the recording of this class is available YouTube. I'm sure your class rep must have shared my link. All the recordings are there. You can listen to the lecture over and over as many times as you want. And all these things that we are saying are in the recommended text. And I recall properly that during my first class with you, when I introduced this course, I told you the textbook that you should buy. So there's really no excuse asking for, what is not missing. Yes.
Okay, thank you, sir.
Charles.
Good evening, sir. Yes, good evening, sir.
Yeah, I can hear you.
Please, sir, I want to ask. Sir, can you hear me? Okay, thank you, sir. Please, I want to ask,
I'm
when you were
trying.
discussing about the indigenous... Sorry,
Can you
sir.
speak to your mic?
About the indigenous... Yes, I'm speaking on my mic, sir. Can you hear me now? Is it better?
A little bit.
Okay, sir. When you're talking about the indigenous judicial system, you said that system actually has...
Sir, please,
of identifying
the
who
document you
commit a
said that we
particular
show on the
crime.
screen is not showing on my on my screen.
Don't bother yourself about that. Charles, I cannot hear you.
Sir, is it better now?
Sir, I've submitted
Sorry, sir. I've submitted the assessments that you give, 10 questions.
You said what?
I saw mine and I said, good afternoon, sir. I said I have already attempted the assessment that you sent, the 10 questions.
Okay. So I don't know why some are claiming that it's not showing on their own system.
So I cannot see any.
The one that attempted, where did you see it?
Sir, it just popped up on my screen. Like, I don't know. I just saw
Are you using a laptop or phone?
No, I'm using my phone and I've done it. I've submitted. I'm using my phone.
So the facility is made available. I mean, is enabled to actually serve everybody at a time. So I don't know the kind of phone you are using. I can see feedback.
So I did it too. I
I
did
can
it too
see
because it popped up.
reports showing on my own screen. So, and I just want to encourage you, although it can still show on the phone, get a laptop, no matter how small, to take your classes. Very soon, more of tests like this will be coming up so that you do not miss out. There will be no room for story. Okay? All right. So, in the absence of other question, I think we call it a day here.
Taking the test.
Why is it that I cannot hear you properly?
So what about you have not done it?
I've not done it, sir.
So I can't see anything now.
Hello?
Sir, can you help us to send the poll test again?
It's automatic, it's launched already, so it's there. I don't know why your own phone is not showing you.
Sir.
Sir, I think it's only. I think we should sue our device owners for discrimination. It's only showing on iPhone. It's not showing on those of us who are on low budget phones.
Samsung. I'm using Samsung and it showed
I'm
on my
using
phone.
the
Point of like
I'm
at
using
the
mine.
top screen.
Those of you that are on low budget phone,
Image or the
did they
silhouette of
stop you from buying
is
iPhone?
there.
Hello, sir. Can you hear me,
You
sir?
pop up on the screen. Side live. You
Sir,
see it.
just
Phone is
click
there.
on
Just
more
click on it.
icon.
What did you say?
Just click on more icon. There's a poll. There's a icon that says more. You can
Yes.
see poll. Yes, after the voice chat, those lines. You can see disconnect audio, meeting settings, and polls.
I
can't
didn't
see
get.
polls here.
I'm not seeing what you are saying here.
Okay, so after the chat icon,
Yes.
reactions, share, record, captions, whiteboard, apps, notes, and more.
Yeah.
Yes, they should click on that. There's a poll icon there that they can click. I just discovered it now. I just found out.
There is a quiz icon, right?
Yes, sir.
It's
And
not,
the questions are there.
you see, let me allow you say it to them again. If you are not speaking, speaking, mute your mic.
Okay.
Mute
Who is
your
that?
mic. Hello?
Yes, sir.
So please, can you repeat that again?
Okay, sir. After the icon of chat, there's reactions, there is share, record, captions, whiteboard, apps, and notes, then more. Then in that more, there's an icon for polls where the questions are there.
You've heard
Hello,
what?
sir.
Yes, I can hear you. Thank you for that. So go to more under the more option. You will see the polls there. You just click on it and try and get high budget phone like iPhone. If that's the accusation you are laying, that the high budget phone could access these things easily. All right, so I'll just give you some few more minutes to attend to it, then that will be the end of the class.
Good evening, sir.
Good evening. Somebody said you don't have money. Why now? Why don't you have money to buy? You don't worry, there will be money very soon. Okay.
Can you hear me, sir?
Yes, I can.
Good evening, sir. Can you hear me,
Yes,
sir?
I can.
Okay, sir.
The what? I can't hear you. Can you try again? All right, so I will allow you to carry on with the test and see you some other time next week by God's grace.
Thank you, sir.
Guys, this
evening, sir. And sir, there are some people that are trying to get in, but they are unable to. They said the network kicked them out and they can't join back. Good evening, sir. Sir, the link is showing it's on hold. So the people that got kicked out are not able to enter the class again. Good evening, sir. Okay, so I don't know if you can hear me. People are still on hold and they are not able to take the test. They said they got kicked out. Some of them were already in class. All of them were already in class and they got kicked out.